Hello and welcome back to the Self-Represented Litigant Society. I am a volunteer. My name is Jason, and I am going to be discussing today pleadings and talking about their effect on the outcome of a case and essentially what it is that should and shouldn't be in pleadings. So basically, a set of pleadings are the initial court documents filed by not one side but both sides in a civil matter. Oh, in some cases, the pleadings may be referred to in different terms. So, for instance, in a family matter, the application in a family matter can be referred to as one part of the pleadings. The reply or the answer in a family matter here in Ontario, that can be definitely something that is referred to as the pleadings of a case. And what we're looking at here on screen, and what we're going to examine in depth here on screen, are two cases that are actual two sets of lawsuits. I have not read these documents. I know that they are here in the Superior Court in Ontario, and that's all that I know about these cases. The one case I think I know a little bit about, the Sammy Yatim case, but aside from that, I don't know anything about what will be found in these sets of pleadings. Now, both of these are Superior Court of Justice cases. And what does that mean? It means that the Superior Court of Justice has jurisdiction of these cases. Here in Ontario, this is a judge who has the authority, essentially, or a jury has the authority to be making decisions on equality. So what we are going to talk about is, the power in the Superior Court of Justice when compared to that, say for instance, in the small claims court here in Ontario. The small claims court here in Ontario is something that can be used as a mechanism to return money that is owed from someone, and it can also be used to essentially demand that property be returned to somebody. Aside from that, the court in small claims court, it doesn't have much power. And that's why in the civil law practice, we see a lot of attorneys, they go straight for Superior Court. They don't even bother thinking about small claims court. But there are so many more advantages if one just thinks about it. There are so many more advantages to bringing an action in Superior Court compared to that in small claims court. So we're going to concentrate primarily, not necessarily on the benefits of Superior Court to small claims court, but we're going to concentrate on what those pleadings actually look like, and the form and the content of pleadings in the Superior Court will have a lot, and I say a lot, of familiarity in small claims court, although it may not be easily seen, because when we look at the forms, the actual forms that you need to fill out in small claims court, everything has it's all ticky box this and ticky box that, a space for your name to be put. When we're taking a look at a document like this, there's nothing here on this form. When the lawyer has to fill out this first page here, there's nothing here. There's no plaintiff here. There's nothing that says defendants here. There's no file number. Actually, the Ontario section up here at the top, that's something that's not even on the form. All this heading section here is absent and missing from a blank Superior Court of Justice form. But when we take a look at a small claims form in the pleadings, in the plaintiff's claim, I think it's referred to in small claims court, the plaintiff's claim will have they'll have a little box right here for the court. They'll have a little box right here for the person's name to fill out and who the defendant is. There a little box for them to be putting their name in there, and then they're going to have their lawyer's name over here in a little box. It's going to be very sterile. It's going to be very much something that an idiot can do. But for the civil claim, for the Superior Court of Justice type of pleadings, which the main pleading is referred to as the statement of claim. The main pleading will be, primarily, this is it right here. There's nowhere, all of this section right here from starting at page, what's showing as page 4 here. All of this section here down is not included in the form, I believe, along with this heading section. This heading section would be on pretty much every document after this. And just to be clear, the statement of defense. So I serve this as the plaintiff. I serve this onto the defendants, and then their documents that they serve onto me, the statement of defense, that is also considered part of the pleadings. And then any reply that I have to any new information in their statement of defense, that would be also considered to be part of what are referred to as pleadings. So, and to translate this, say for instance, into family court, for instance, the application starts off the matter, starts off the family law matter, and then the answer in Ontario here is what the form is referred to as. That answer is also referred to as pleadings, or the set of pleadings. In the civil court system in Superior Court here in Ontario, pleadings are quote unquote closed once once the statement of claim is filed and served, as well as the defendant serving their statement of defense, and an opportunity for me to then make a reply on any new information raised in the statement of defense. So those 3 sets of documents, once they're all completed, once they're all filed and served, then we move on to a different stage of the lawsuit. But right now, we are just taking a look at and examining and making some commentary on what makes up a good set of pleadings. And I can tell you that these 2 documents, I got them from very reputable law firms. So you can expect some very good language to be used, some very simplified language perhaps to be used in these documents. So let's get started. Let's take a look in depth at these 2 statements of claim. We're going to start off with this Sammy Yatim case. So right here at the top, these are the parties, and you're going to find this on pretty much any statement of claim or any application. You're going to find a section at the top of the documents for the parties to be named. And if you don't put, for instance, I can see here James Forchillo, Police Chief William Blair, Toronto Police Services Board. This stands out to me as being something that, if this is, if this body, this police services board, if this is named incorrectly somewhere down the road, there could be some issue that a lawyer takes with that being misnamed. And then there could be some issues raised as to the legitimacy, as to, should this police services board, should they have been named in a certain way, and maybe some amendments are, maybe permission from the court is given to rename one of the defendants, for instance. Um, and when when it boils down to it, I'm gonna take a look and really kind of scrutinize some of the language that they're using, but I'm gonna suspect that the lawyer that produced this statement of claim, that he knows what he's doing, that he's a well-known lawyer in the Toronto, Ontario area, and he's known for doing big lawsuits like these, especially suing the police. So what we're talking about here is somebody who has died, obviously. So the administrator of the estate of Sammy Yatim. So it says that he's deceased. So Sarah Ann Yatim, by her litigation guardian, Sahar Bahati. So these people. So a litigation guardian is somebody that can act for somebody, and so the order and the naming of parties is extremely important. But what we're going to get into the second section of the pleadings, what we're going to get into is we're going to really see a breakdown of who the parties are and their relationship to each other. So that's really like a standard set of this is really like a standard section 1, let's call it. So section 1 being, this is the introduction of this lawsuit. This is like the title page, if you will, of the lawsuit. And this really sets out who the parties are, what court is hearing this, what the file number is, the roles of the parties are listed right here. And then this section right here that I'm gonna say is still in section number 1. This is sort of like a generalized notice to the defendant. So when they're served with this, it's telling them that they have 20 days after the statement of claim to serve a statement of defense or a notice of intent to defend, to get an extra 10 days, I think. But generally speaking, this is generally prescribed by the courts. As far as this language here, this is something that the lawyer would have put in right here, $50,000 for costs. So essentially what the lawyer is saying right here, if you pay the plaintiff's claim, and this is pretty much, you're going to find this kind of general heading here, and notice to a defendant on every plaintiff's claim or every statement of claim. But this is right here. This is an indicator as to how much the lawyer, just for drafting up this document, just for doing the research and everything involved with the preparation of this document, he's saying that his time is worth $50,000 for just drafting up this 17-page document. And it's kind of astounding, but that's kind of the going rate. But it's saying, not only do you have to pay, if you pay the plaintiff's claim in full. So that's saying to the defendant that if you pay the amount of money that we're claiming and $50,000, then all of this goes away. But most of the time, I would say 0% of the time, maybe 1% of the time, the defendant's going to get this document and say, oh yeah, I'm just going to pay this right away and pay this $50,000 in costs. This $50,000 in costs, as soon as this gets filed, as soon as this gets served, then comes, the raising of this figure right here. This cost figure, this legal costs, these legal costs will go upwards of, depending on how long this goes on for, this, those may get into six figures easily. I would say at least $500,000 if this goes to trial. And that's just the legal expense that the lawyer is going to claim for the time in putting this document together and representing the client all throughout. That's sort of an easy kind of an expense to justify. So the date as to when this was issued by the court. So this was issued by the court on the 11th of October 2013, and this is the registrar. So the registrar of the courthouse, the registrar at the courthouse, the clerk at the courthouse signed this, and this was at 393 University Avenue in Toronto. That's where the courthouse is, and this is the court file number. So if I wanted to go and take a look at what actually happened in this file, I could go and pull this file at that courthouse. I can't call them up and say, can I have information about this case? They just won't do that over the phone. Actually, this courthouse has a records department, so you can go and make a records request in that specific department. It's a very big courthouse, and it's a very busy courthouse. So this is all kind of, standard procedure here, all part of Section 1, which is like the title page, the introduction to this lawsuit. And these are all the parties and where the plaintiff believes that they can be found. So when we're taking a look at serving these parties, if I give this to my process server, they're going to go to each of these addresses to try and serve each of these parties. The John Doe is a question to me. I don't know who the John Doe is referring to, or what the John Doe, or there's two John Doe and Jane Doe here. So a female officer and an unnamed male officer. So these two parties, I would print a copy of the lawsuit, and I would be handing it over when I'm serving the police services board or the chief. They could accept service for these unknown police officers, and I'm positive that their role, whatever role that these officers played, that the author of this document, a very well-known lawyer, he's going to be naming what those circumstances are. All right, moving on to page 4. So this is the claims section. Let's call this section number 2. Section number 2 is basically what it is that I'm claiming, and we're getting into specific numbers here. While these may be estimates, some of these, like special costs, special damages, some of these special damages aren't going to be listed here, but they're going to be disclosed at some time prior to the outset of trial. Special damages can be like any kind of out-of-pocket expenses that I incurred, such as the lawsuit, or sorry, the funeral, I should say, of Sammy Yatim. If I'm dealing with someone who's deceased, most likely the funeral expenses has something to do with the claim. although I'm not exactly sure about this case circumstances. This case's circumstances, I mean, I think that I know what this case is about, but I'm not positive. Both of these statements of claim I picked at random, and I just noted that they were both from reputable law firms. So you can see here, this is a lot of money that is being claimed from these parties, and for the most part, aggravated. And so this sum right here, I mean, okay, so let's break this down into two categories here. We have the estate making a claim, and we also have Sahar Bahati and Sarah Yatim making a claim. Let's see if there's any. No, yeah. So those are the two people making a claim, and we have these two separate entities. Let's call them. These should be listed right here, and they are. So Sahar Bahati on her own behalf, and the administrator of the estate of Sammy Yatim, deceased. So since a deceased person can't be suing someone, their estate can. And Sarah Ann Yatim by her litigation guardian. So we have one party here, we have the estate which represents another party, and then we have a third party right here, which is the litigation. So Sarah by her litigation guardian. Okay, so what I'm thinking is this is a sister maybe. I'm not sure who this is. Like, this is probably somebody who's underage if they have a litigation guardian. And so if someone, for instance, is unaware that there is a deceased person, essentially what can happen is that if that person gets a litigation guardian, and in this case Sahar Bahati is both a litigation guardian and a party, so when we're talking about these litigation guardians, that typically means that somebody's either underage or under disability. I'm gonna take a guess here in the dark that this is somebody who's underage. I have no reason to suspect it's somebody under disability, but I guess the statement of claim will tell us more. But yeah, as you can see now, we have two separate main paragraphs dedicated to what each person is making a claim against. Detailing out what claims are being made against the parties. And we are not, so right here, I'm having a thought. I'm having a thought that this should be outlining who the claim is against. And if it doesn't name who the claim is against, because I can break down my claim right here. I can break down my claim here in this section and say that, for instance, the Police Services Board, I'm just making a claim against them for negligence, for instance. Or, because I wouldn't necessarily make a claim against the Police Services Board for assault and battery, because a Police Services Board can't necessarily assault me. And what I'm thinking is that the officer here, Constable Forchillo, he did something wrong, and he essentially, by virtue of him doing something wrong as a police officer, the Police Services Board is held vicariously vicariously liable for his actions as a police officer, is what I'm thinking. And that would be prescribed in the Police Services Act in Ontario. But I'm not going to get into the legal, so the I'm not going to get into legal arguments here. I'm just going to try and break down, for you, probably who has, someone who has never seen a document like this, before starting a lawsuit, or maybe you have received a document like this. What is it supposed to look like? And I'll tell you that this is, primarily what it's supposed to look like. So section 2 here, the claim section, we have two separate entities making claims. And so Sarah and Sahar are making basically a generalized claim in different amounts than the estate is making a claim. So for instance, you can see negligence here. The estate is asking for $2 million. In addition to that, Sahar and Sarah are asking for $1 million in damages for negligent infliction of mental distress. Negligent infliction of mental distress wouldn't be over here if this is so if this person was killed as a result of the police officer, and that's what I'm guessing here. So this person wouldn't have suffered negligent infliction of mental distress, and these people are most likely family members. Actually, yeah. So Family Law Act is being claimed here. So under the Family Law Act here in Ontario, if I have a family member who has been wronged in some way, I can make a claim against the people that have wronged against him. So if someone has died, if I have a family member that has died, the Family Law Act actually gives me the authority to make a lawsuit against a third party that I may not have been personally damaged by, but a family member would have been damaged by in some way. So all of these are kind of standard sets of asks from the court, and these are asks. These are not, this is not what somebody is going to win most likely. If this were to have gone to trial, and I doubt this has gone to trial, I will take a look after reviewing the claim in its entirety. I'll take a look after and see if this went to trial, but most likely this did not go to trial. Most likely this was settled somewhere along the way. And I can say from my personal experience that if you ask for, right here's $4 million, $5 million, $6 million, $7 million, $8 million, and if you ask for $8 million in damages, and if you settle somewhere along the way before you get to trial, you're not getting $8 million. The lawyer is asking for this amount of money, and if the lawyer doesn't get this amount of money at trial, then it becomes problematic for that lawyer. Then it becomes that lawyer is in a position of loss, basically. That the lawyer is thought of in this adversarial system. The lawyer is thought of as having lost, because in his pleadings, in the pleadings here that he drafted out initially, he said that he was looking for $8 million. And if he doesn't get $8 million, that means that he's going to be considered, partially, he partially lost his case. Even if he gets, $2 million, for instance. So yeah, this is the standard section 2 here, the claim section. This is, standard legalese, such further and other relief as this honorable court deems just. This is sort of like a cover-all type of statement that if if I didn't cover all my, if I didn't cross all my T's and dot all my I's, that this statement right here can save me. That this statement right here is something that catches all when it comes to, asking the court for certain damages. Moving on, let's call this introduction section. Let's call this section 3. So section 3 will be dedicated to giving some background information. The introductions, actually I can see the parties section is coming up. Typically I would suggest that these two sections are interchangeable. That the party section can come before the introduction, that there's no requirement for introduction here, that this is really up to the lawyer to be making headings like these when it comes to the bulk of this document. The bulk of this document is going to be, basically, the lawyer authoring this as basically a story. And how you tell that story, how powerful that story is, will determine the level of success of the case for that lawyer. And if you have weak pleadings, most likely you're going to have a weak case. So, your case lives and dies by your statement of claim here. So if you have a weak statement of claim, and you don't have everything well organized, and your case doesn't fit within what I'm saying, how I've been damaged, then my case can easily be dismissed. Okay, introduction. In the early morning hours of July 27, 2013, Sammy Yatim, an 18-year-old resident of Toronto, Ontario, was shot and killed on a Toronto Transit Commission. Oh my gosh. So this is the story of the guy who was, I think he pulled out his penis on the bus. Or not on a bus, on a streetcar. And he had a knife. Yeah. So, Sammy, who had just finished high school, so in July, so this is a month or so after the end of high school. Sammy, who had just finished high school, was experiencing a period of emotional disturbance at the time he was shot. So that's a huge acknowledgement right there that Sammy was experiencing an emotional disturbance. And what that emotional disturbance is, most likely this document isn't going to go into that. If I'm the author of this document, I'm wanting to be keeping these strokes that I'm painting here, if you will. I'm wanting to be keeping the strokes here broad. I'm wanting to be casting a wide net on what my accusations are and what I say the facts are. So it's hard for some of this stuff to be disproved or proved, if you will, depending on what the case is. But if I get too specific, then there can be an issue with that. And I'll probably get into that a little bit. Shot and killed on a Toronto Transit Commission streetcar by the defendant. Wow. So that's Forchillo. Sammy, who had just finished high school, was experiencing a period of emotional disturbance at the time he was shot. At the time of the shooting, Sammy was alone in a streetcar that was surrounded by approximately 20 police officers who are employed by the Toronto Police Services Board. One of these officers, PC Forchillo, discharged his firearm 9 times. Oh my gosh. 9 times in the direction of Sammy, striking him 8 times in total. So a fact like that is, that's something that would rely on criminal court to make some kind of, or maybe not the police, what's the oversight body for the police? There's an oversight body for the police, and they would probably have come to this conclusion right here. But this is reading as if it's, this is solid fact. There's no disputing this. Although July 2013, when was this lawsuit filed? October. So this was filed a few months afterwards. I don't know that they would have access to that report afterwards that quickly, but who knows? I mean, I think this was a pretty high-profile case, and I would think that that's something that would become public knowledge pretty fast. So 20 police officers. One of these officers discharges. Okay, so he discharges his gun 9 times, and he hits Sammy 8 times. None of the other attending police officers discharged their firearms. After Sammy had been mortally wounded and lay defenseless on the floor of the streetcar, Officer John Doe fired his taser into Sammy. Oh my gosh. He was tasered after he was shot 8 times. The defendant, PC Forchillo, has been discharged with second-degree murder in relation to the... Oh, has been charged. I'm going dyslexic for a moment here. Has been charged with second-degree murder in relation to the shooting of Sammy. Sammy, who at all material times was 18 years old. Okay, so we're moving on to another section here. So this was just the introduction section. And again, typically the introduction can come after, talking about the parties section. So we're at section 3 here. So section 4 here is the parties. We're just going to be talking about now the relationship. So that gives us some basic background information. Now we're going to talk in depth about who the parties are and what their relationships are to each other. And paragraph by paragraph, you're going to see one paragraph is going to be dedicated just to that particular party. So Sammy, who at all material times was 18 years old and a resident of the city of Toronto in the province of Ontario, died intestate. He was a high school student at the time of his death, or he was just finished high school. That seems weird that this is sort of conflicting information already. He was a high school student at the time of his death. These two paragraphs conflict with each other as far as that particular statement goes. It's not that big of a point, but when I'm looking at this from the defense perspective, this is what I'm looking at. I'm looking at what are the holes in the story that's being told here. And essentially, this is a story that's being told. It's being told to the court. The plaintiffs, Sahar Bahadi and Sarah Ann Yatim, date of birth June 25th, 1996, are residents of the city, respectively, the mother and sister. Okay, so these are the mom and the sister of Sammy. And that's why now we go back up here and take a look at her litigation guardian. So she is probably underage. Actually, 1996, 2000. So the plaintiffs, so these are the plaintiffs here, the mom and the sister. They enjoyed a close and loving relationship with their son and brother and were dependent on him for care, companionship, and guidance. If I'm looking at this from the perspective of the defense, I'm really questioning whether or not that this was actually true. And through the course of the trial, through the course of this case, through discovery, I'm going to be wanting to question them about their relationship and actually find out if this was true. Because if this is not true, for instance, if this is not true, then the Family Law Act, that may be a trigger for them as family members. That may be a trigger for them to make a claim that they may have to have some kind of dependence as far as companionship and guidance goes. That's a completely separate issue. From the perspective of the defense, that's what I'm thinking about. I'm thinking about holes in the story that's being told. From the plaintiff, I want to be painting a very broad picture, something that shows sympathy, and because essentially this would go before a trial by jury, most likely. Probably not in front of a judge. Okay, the defendant, PC Forcello is a resident of province of Ontario and was all at all material times employed as a police officer with the Toronto Police Service. This defendant intentionally shot and killed Sammy Yatim without justification or excuse. That is a pretty broad statement to make, given that this lawsuit is being filed only a couple months after this incident. Most likely, if this Forcello was charged, I think he was charged. He's charged with second-degree murder, I think it says. Second-degree murder. Okay, so if he's charged with second-degree murder, most likely he's not going to be pleading guilty a couple months after this was these events. I don't know how they would have access to this information. I think they're making a very broad statement here to be proven at a later time. But if I do recall correctly, I think there was, video of this interaction, and obviously that video is a very powerful piece of evidence when it comes to cases like this. The defendant is a resident employed by the police. The defendant intentionally shot and killed. In the alternative, so they're saying one statement, and this is completely legal and allowed. The rules of civil procedure actually allow you to plead in the alternative. And what does that mean? It means that I can make one set of allegations, and then I can make a separate set of allegations if I have reasonable grounds to do so, based on an alternative theory that I'm going to put forward to the jury. What they're saying here is that this defendant intentionally shot and killed him. And then they're also saying, in the alternative, this defendant recklessly acted, he acted recklessly or negligently, and thereby caused his death. Either way, he caused his death, whether it was by negligence or being reckless or intentionally. That's essentially what they're saying here in these two sentences. This defendant is liable to the plaintiffs for assault and battery. I don't know that that's actually true. I don't know that the Family Law Act would empower someone to claim for assault and battery. Well, okay, so they're saying plaintiffs. The plaintiffs would also cover his estate. So his estate actually, he was assaulted and battered by virtue of being shot by bullets. Whether or not there was grounds to do so is another story. I don't know that all of that is painted clearly enough in the video that was publicly displayed. I don't know enough about this case to really kind of say whether or not that I don't know that I can say that the daughter, the mom and the sister, I don't know that they can qualify for this statement here, that they can qualify for being assaulted and battered if it wasn't them that wasn't assaulted and battered. With that all said, for sure his estate can make that claim, and they are probably the administrators of his estate. Misfeasance in public office, which would be, these are torts here. So now we're talking about tort law. And if we're talking about tort law, it would be good to follow along on a basic Wikipedia page that would be dedicated to talking about torts. Because once you take a look at the tort of assault or assault and battery, then you can see that there's certain elements that have to be met for assault and battery to be present. And those elements now have to be spoken in word form, or have to be listed in word in dialogue in the actual description of the case for there to be a successful claim of assault and battery. And that comes at trial. It's not something that would come at any point before that, with exception. So they're claiming against the officer, assault and battery, misfeasance in public office, which means, doing wrong while holding a seat in public office, which, covers police officers, negligence, and causing nervous shock. So negligence is kind of standard. If I act negligently, that can that can be a very, very broad tort. If you look at the tort of negligence, I believe that there's five different elements that are that are associated to negligence, and you should take a look at what the tort law, what it says on Wikipedia when it comes to negligence in tort law, and you'll see what those elements of negligence are. Police Board is a municipal police services board incorporated pursuant to the provisions of the Police Services Act, and at all material times was responsible for the provision of police services, law enforcement, and crime prevention in the City of Toronto. The board, by virtue of Section 50.50 sub 1 of the Police Services Act, as amended and common law, is liable in respect of torts committed by employees of the Toronto Police Service. So what it's saying there is it's actually arguing a piece of law. We're not necessarily arguing law in a pleading, but what's happening here is that we're signaling to the court that the board is, by virtue of this particular section, they're vicariously liable for the actions of Forchillo, and that's why that they're a defendant. Ultimately, once the Police Services Board is served, they're going to retain one lawyer, and that one lawyer is going to most likely cover all of the police defendants here, including the chief of police. And that one lawyer will represent, or that one law firm, I should say, will represent the interests of all the police officers involved. And then, each one of these parties won't have to lawyer up and get separate lawyers. But typically, if these parties were unrelated, they would get separate lawyers, and they would have to file separate statements of defense. But most likely, they would have filed one sole statement of defense covering all of the police officers, and that way they're saving a little bit of money. And then once the Police Services Board comes into this, then comes the insurance company for the Police Services Board. And they would be essentially stepping up to the table if, for instance, throughout the course of the lawsuit, they would be essentially responsible for payment outside a certain amount, I believe. And I'm not sure what that amount is, but if you're really curious about that, you can maybe call your local municipality and find out what their limits are on maybe it's a $2 million limit on their policy, and anything above that $2 million, the City of Toronto, the taxpayers, may be on the hook for. That may come out of the general budget for the City of Toronto. In any case, now we're getting into new sections. So now we're in section 5. And now this essentially can be paired together with that introduction section. Sometimes that introduction section is important, but it's really kind of, unknown right now as to, I don't think that there is any common practice when it comes to breaking down the particular sections. So this introduction section, this may not be in every single statement of claim that you see. You're not going to see, it even labeled as introduction sometimes. Sometimes this heading is going to be, for instance, background. It's up to the lawyer or the person drafting this. And if you're drafting this, you're a self-represented litigant. There's no right or wrong way to list a section like this or to list a heading like this. But I can say that, you're telling a story, and it's good to be organized. It's good to, generally stick to one thought per paragraph throughout the whole statement of claim, or throughout the whole defense statement of defense. That's general rule of thumb. Stick to one thought per paragraph. And as you can see, we're talking about the chief of police here, and they're saying that he's liable because he was the chief of police and he was supposed to be overseeing his officers, ensuring that they had proper training, etc., that they followed their training, blah blah blah. The way a judgment would come down like this would typically it would typically serve to kind of be as just as possible. And for instance, the police services board may be held liable for, I don't know, 20% of the damages. uh the officer here for Chillo, he may be held for 50% of the damages, and the other officers may be held for 10 or 15% each. So it may, a decision may come down like that, from a jury or from a judge, depending on who is going to hear this case. That's kind of irrelevant, because I don't really want to focus on, pinpointing this is who's going to be held liable in this particular case. I'm not doing an assessment on this case. I'm just we're just making commentary, if you will, on what's in here and why it's in here. And this is a good learning tool for you if you're drafting any statement of claim. It's good to be as clear as possible at all material times whenever you write something. And keep in mind, this whole document basically is a set of accusations. They're not proven in a court of law yet. And if all these police defendants will have any say in this, it won't ever be brought to a court of law, because it will get settled. The plaintiffs will get paid prior to that decision being made. So most likely this has already settled. That settlement will most likely be confidential. If you were to go down to that courthouse and pull that file, that may even be restricted material now. You may not even be able to pull that file. Section number 5 here are the detailing of all of the facts. And I'm not going to go through all of the facts, but as you can see here, it is a very particular set of wording that is going to favor the plaintiff side of this. It's not necessarily going to favor the defense's side of this, although somewhere in here, in one of these one set of facts will usually cover one paragraph. But when we're talking about these facts, these are broad stroke accusations most of the time. If I'm conceding as a plaintiff, it looks better on me. So if I'm making some kind of concession that, yes, for instance, let's say Sammy was on drugs, for instance, and I know that he was on drugs, it's more favorable to me that I put that in my statement of claim, that I make an accusation that my brother or that my son was on drugs that evening, and that was, partly to blame for his behavior. Instead of, on the flip side, what can be done in the statement of defense from the police officer's perspective is they can point the finger at the mom for having a piss poor relationship with their son. Or they can, maybe the sister gave Sammy the drugs. And I'm not actually speaking of fact here. Just to be clear, I'm making hypothetical situations that are, meant to be helping people learn from the errors of other people. But when we're talking about the plaintiff's claim or the statement of claim, It's a set of accusations. And the more reasonable a plaintiff that I can be, the better. The more fair and objective that I can be with my accusations, then it will be looked at more graciously when it's time to be judged, when the jury is going to now take a look at what is described in my claim, and does that line up to the facts that have been actually proven at trial. So keep in mind, if I say something here, if I make a statement here that I can't prove or that I know is not true, that is not a good thing. I have to be speaking to what I know the facts are. And if I don't know all the facts, I can say something like up here, where in the alternative, you know, that, and now what has to happen? So I'm saying here in this paragraph number 10 that the defendant acted in that the defendant intentionally shot and killed Sammy. And then in the alternative, that that the defendant acted recklessly and or negligently. Those are two separate states of mind. And whether or not, either are true, they're an accusation that now have to be listed in detail down here in the events section. So now I have to relay everything in that introduction section. I have to now relay what those facts are in these separate paragraphs here. And now we're going to get into another section. So section number 6, where I'm actually talking about the liability. And this is sort of argument, but it's not necessarily out of turn to be making these kind of arguments in a statement of claim. But most legal arguments should be left out of pleadings. Most statements of claim or most pleadings shouldn't be shouldn't be trying to argue law in the actual statement of claim, in the pleadings. And we don't do that because we leave that until all the facts are in, until we go to trial, until all of the witnesses have testified at the trial, until all the documents have been assessed. That's when we make arguments of law. We don't necessarily make them here, but what we're doing here in section number 6 is we're talking about how, if believed, if the jury or the judge believes all the facts all up here in section 5, now these are all the elements of assault and battery. So he negligently applied force to Sammy without his consent. As regards to PC Forchillo, he intentionally applied deadly force to the person of Sammy Yatim. So these are all the elements now that are now being satisfied, that are speaking to earlier paragraphs of the alleged facts. These are now kind of going to outline each of these causes of action or these torts. For instance, where is it here? Oh yeah. So all these torts right here: damages for negligence, assault and battery, misfeasance in public office, and infliction of mental distress, negligent infliction of mental distress. All of these are the torts right now that need to be broken down and described in detail as to how the facts apply to each of those different torts. And if you take a look at each of the elements in those in a Wikipedia page, for instance, on misfeasance in public office, now you're going to see that those facts now have to fit within the puzzle pieces of what those elements are. So take a look at misfeasance in public office. Take a look at the facts now, at what they're saying here. So these are the facts that have already been described above. The defendant police officers are holders of public office. The plaintiffs repeat and rely upon the facts as set out above and state that the officers deliberately violated the law in committing an assault on Sammy. In the alternative, the officers were reckless and or willfully blind to whether their actions violated the law. So as you can see here, now we're breaking down each particular claim, or each tort, I should say, of how it is that those police officers violated those torts and how they wronged the plaintiffs. Section 7 here, let's call it Section 7, the damages section. Plaintiffs state that the negligence and intentional torts of the defendants individually and or collectively cause the injuries. So essentially all I'm saying here is that with all the facts taken into account, that the actions or omissions of the police officers caused the actual damages, caused the plaintiffs to suffer those damages. And, this is somewhat arguing the law right here, but what we're not doing is we're not talking about any transcripts of video, for instance. If there's a video of the interaction, I know that there's a video. I've seen the video. I know I've seen it some years ago of the interaction from the police officers and Sammy on the streetcar. If there's a transcript, for instance, that they have in their possession, this is not the appropriate place to be talking about it. It may be okay to list in here in the facts section. It may be okay to put one quote in here. It's not okay, for instance, to list out, on this particular date, Sammy sent a text message to somebody saying he wanted to die. And on this particular date, Sammy sent a text message saying that he wanted police officers to kill him, for instance. And I don't know that Sammy said that. I'm just making this up. And I'm just saying that as an example. That we wouldn't plead evidence in a statement of claim. There's very few times where a lawyer will plead evidence or, list out particulars like text messages or statements that are being made, unless it's like completely, unless it's absolutely undisputed, or unless it's like a statement like, it was a sunny day. If it wasn't a sunny day, and I say that it was a sunny day, it's likely that that statement shouldn't be in there because it can be refuted. If there's video evidence that shows me that it wasn't a sunny day, then I look like an idiot for putting that in my statement of claim. So there's very few times where you'll see in claims like these, in statements of claim, where you'll see actual lawyers pleading evidence or listing that evidence inside their statement of claim. Usually that will come at a later point. That will come either at trial or in settlement discussions after we've had a chance to go through discovery. And that's page 1415. So the plaintiffs have been out of pocket as a direct result of the wrongful acts of the defendants. Okay, there we go. Funeral and associated expenses, legal fees, so coroner's inquest. So all these are what are going to be referred to as special damages, and those would be something that can be proven at a later time. But most of the things, so the plaintiffs plead and rely on the relevant portions of the Family Law Act. In particular, Sammy's mother and sister enjoyed a close and loving relationship with him and have suffered the loss of his guidance, care, and companionship as a result of his wrongful death. These plaintiffs have also suffered pecuniary loss. So that's monetary loss. This section here, because we're saying it, because I'm putting it in my statement of claim, now it has to be proven And if the other side now, if in the statement of defense it says that they didn't have a good relationship, that Sammy had been kicked out of his house and he was on the rocks and he was homeless and whatever, if this turns out to be a lie, then this can, at trial, and I'm not saying I'm not saying that it was a lie, I'm just saying it as an example. If this was something that was a lie, that I'm relying on this section, that this can be $1 million less in damages that I can make claim against the Police Services Board and the police officers. And it may affect the rest of my claim. I'm not sure that the Family Law Act is the jurisdiction or is the authority necessary to make a claim for infliction of negligent infliction of mental distress. I'm not sure. Special damages, I'm sure special damages can be claimed from a family member, but the Family Law Act here, this really triggers a big thing here, because the Family Law Act actually empowers family members who have been wronged to make claim against a third party. If their family member was wronged, they can essentially make claim. Okay, so getting to the end of this lawsuit. So now we're talking about all the particulars of how all those damages break down here in this damages section. Yeah, so this last section here, this section 7, I called it, damages. This is really getting into mentioning the authority that some of these damages come from. So, pursuant to Section 38 of the Trustee Act, they're acting in regards to their role as estate administrators. And that's why the estate is claiming punitive damages, looking to punish the Police Services Board for the death of Sammy. And guess, even if Sammy's mom and sister aren't successful, Sammy's estate will be successful, and by virtue of them being the administrators of the estate, they will be somewhat successful. So, they're trying to double prong this here. This is sort of standard procedure to try and cast, again, the widest net possible when it comes to the actual damages that are being suffered, parties who are actually making those claims. The plaintiffs propose that this action be tried in Toronto. I could see that the defense would say that it shouldn't be tried in Toronto because this had so much public outcry against the police officers in this matter that they could say that it wouldn't get a fair trial. So that's the breakdown. This is the final page here, is the back sheet. This is pretty much found on every set of court documents in this file now. So for every document that's being filed, it needs a back sheet. It won't say statement of claim. It will be like, if there's a motion and this was a motion record, this would have, instead of statement of claim, it would say motion record. Otherwise, this is sort of a section on here that the judges make notes and endorsements over here. Yeah, that's the document. That's the statement of claim. This is the Sammy Yatim file. I think we're going to split this up into 2 videos now. We'll continue with the other statement of claim in a separate video. Thanks for watching. And if you have any comments or questions, feel free to leave them in the section below, and we will hopefully see you next time. Thank you again for watching. I'm Jason with the Self-Represented Litigant Society, and you can visit our website at irepmyself.com if you're in a position that you need support for representing yourself in a claim like this.